Your Honor, Mr. Williams is here for a pretrial. He has come to a resolution with Mr. Siller and Ms. Coons. He's going to plead at a count of operating while visibly impaired.
That's correct.
Okay. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Martell Williams.
Sir, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor. It is punishable by up to 93 days in jail, up to a $300 fine plus court cost. The court could order any rehabilitative services or community service the court deems necessary. The court could also order your vehicle immobilized. The court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Understand.
Understanding that, still wish to plead guilty?
Yes.
May 25th, 2023, at the location of Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had like a beer and a half the night before and like a 12 ounce when I woke up.
Okay.
In a tense courtroom, Mr. Williams stands before the judge for a hearing that could seriously change his future. A plea offer is on the table. Plead guilty to driving while impaired. This isn't a small matter. It could mean up to 93 days in jail, a $300 fine, and required programs he must complete. The atmosphere is heavy. Every word from the judge lands firmly. Mr. Williams isn't just speaking for himself now. He's facing the full weight of the legal system.
Were you stopped by the police or was there an accident?
No, I was just pulling over because of the construction that they had. So when I was sitting there, the police just came up and was asking me what was going on.
Okay. You're not disputing the right of the police to stop you in this instance? Okay. Were you ultimately arrested?
Yes.
Were you taken to the hospital?
Hospital, yes.
Okay. Was there a blood draw? What were the results of that blood draw?
I never seen the results, but after that, I came here.
Okay. If I told you it were 0.186, counsel, would you stipulate to that?
We would, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
I don't think it was, but.
Well.
You don't want to plead guilty?
Oh yeah, I do want to plead guilty, but I wasn't like drunk or nothing. But, you know.
In a tense courtroom, Mr. Williams stands before the judge for a hearing that could seriously change his future. A plea offer is on the table. Plead guilty to driving while impaired. This isn't a small matter. It could mean up to 93 days in jail, a $300 fine, and required programs he must complete. The atmosphere is heavy. Every word from the judge lands firmly. Mr. Williams isn't just speaking for himself now. He's facing the full weight of the legal system.
You're a 0.186. So you think that
I don't know.
you could, hold on a second. You are a 0.186. And so if you were operating that motor vehicle, you don't think others would have noticed that you were impaired?
Well, probably, yes.
Okay, so I'll ask the question.
Coming from the police, yes.
Yeah, okay, so let me ask the question again. Taking everything into consideration, on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel.
I'm supposed to do that tomorrow at 1 o'clock over the phone.
Where?
On the phone at 1 o'clock.
What?
The assessment.
Okay.
With care?
It's through Washtenaw County, I know that.
He keeps saying, I wasn't drunk, but the law doesn't care how he felt. It cares how he appeared to others. The judge presses him harder. Would people watching you think you were impaired? After a pause, he quietly admits, probably yes. His denial shifts into acceptance. The court accepts his guilty plea. One charge is dropped. The judge delivers the sentence, but the process isn't finished yet. Mr. Williams must now complete alcohol screening and attend a victim impact panel. His punishment begins, but so does the chance to reflect on his actions.
Do you have another pending case?
No, my probation officer,
So,
well, Mr. Coons knows this already, but
So somebody's giving him another assessment, so.
okay.
Sentencing in this matter, April 10th, 2024, 9 a.m., or as your invite indicates.
Before you give away the file, Your Honor, there's a bench warrant in the file for a bond violation.
There it is.
For another violation, Mr. Williams and Ms. Coons did speak of it, about it. They would like to set it for a hearing. He does deny the allegation of consuming alcohol at this time.
The two. He wants all of that set, he wants it set for a hearing?
Yeah.
I'm gonna move to dismiss it.
The bond violation?
He says.
Yeah. Well, I'll tell you what.
Then comes the twist. A bench warrant is issued after claims he broke his bond terms by drinking again. He firmly denies it, demanding a hearing to explain himself. He refuses to back down, insisting it wasn't alcohol. It was hair conditioner that contained alcohol. Yes, conditioner. The courtroom grows tense. To the court, these aren't explanations. They're last-ditch efforts against a system that won't flinch. But he insists on defending himself. The judge agrees. The next step, an unusual, slippery fight over what's true.
Does he really want to do that?
I don't want to get into it necessarily, but I mean, the level was very low. He thinks that there was another reason of
Oh boy.
why it detected alcohol. It was a
Much like not being visibly impaired.
hair product, yes.
because when I got
Oh, really?
when I got released from jail on the 7th of last month, I got my hair.
Okay, what kind of hair product?
When I read the bottle afterwards,
Yeah, I know. What kind of hair product?
conditioner.
Conditioner? So that had alcohol in it. A lot of alcohol.
Whatever.
Hold on. It had a lot of alcohol in it. Is that what you're telling me?
That's all it could be because they told me to
Really? Okay.
change my,
So-
product.
I'm going to say this. I kind of know about your hair. Just saying. And if you put too much alcohol on it, other things happen.
Things take an even stranger turn. Williams argues that the alcohol in his system wasn't from drinking. It came from using a hair product that contained alcohol. The judge listens carefully, then questions it. Hair products can have alcohol, but enough to trigger test results. The judge reviews the reports. Blood levels are normal, but hair tests are showing high. It's a mix of confusion and doubt. The judge doesn't throw out the claim, but he's clearly skeptical. Still, he grants the hearing. Now, science and suspicion are set to face off in court.
Like you don't have hair, because it will break off and fall out. So I'm looking at these numbers here, and yeah, they're low for the human body, high for hair.
Well, Your Honor,
No, I want to have a hearing.
if you would like to,
No. You've asked for one.
I do.
I'm just here. I am here to serve.
I did hear Mr. Stiller say he'd be willing to dismiss.
I know, but I'm not.
Okay. Then we will hold the hearing.
Yes, we'll have a hearing. Give me a date. I need a date before April 10th so that the findings of the hearing can be taken into account at sentencing. Let's do it on trial week. At the end of this month.
Okay.
What day?
We can do Wednesday, March 27th at 1 p.m.
Okay. So, bond violation hearing on hair product.
The date is set, March 27th, 2024 at 1 p.m. A bond violation hearing, all over hair conditioner. It sounds odd, but the stakes are real. This isn't just courtroom drama, it's a showdown between evidence and doubt. Mr. Williams even jokes about calling witnesses from his barber shop. The judge stays stone-faced. For now, the bench warrant is on hold until the hearing. Truth or excuse? His entire defense now rests on one unusual claim: alcohol, but not from drinking.
March 27th, 2024. Okay.
1 p.m.
1 p.m. I can't wait.
That 27, 24.
27.
All right, and
We're gonna bring some people from the shop, barber shop. They'll be okay. I'm just saying. Okay, we'll see you then. What else? Is there something else?
I would ask that the warrant be recalled
Oh,
pending the hearing.
sure.
Thank you.
We'll recall the warrant.
I got other cases.
I'm good.
So, just curiosity, after the conditioner, did you put something else on your hair?
It was, I mean, when I got out of jail,
Okay, no, never
I
mind.
got
Never
my
mind.
hair-
We'll figure it out at the hearing.
All
All
right.
right, talk to you. All right, bye-bye. What? I know. I didn't expect it.
Sean Jenkins steps up. Another case, another man facing the judge. His offense? Simple double parking. But this moment matters. The court offers him a deal. Admit partial guilt, and one charge will be dropped. Jenkins agrees. He politely asks for 90 days to pay his fine. A joke about jail doesn't land, but something more important does: respect. The moment his name was called, he quietly removed his hat. No drama, just a small gesture that spoke volumes. Sometimes it's the little things that change how you're seen.
90 days because I got other obligations.
How many?
I got 90 days because I have other obligations.
He wants 90 days in jail?
90 days to pay, Your Honor, please.
No, I thought he was asking.
No.
I'm kidding, Mr. Jenkins.
Yeah, I prefer to stay where I'm at right
He's
now.
like, I didn't find that funny. I didn't. Tell you what, Mr. Jenkins, here's what I'm going to do. I'm going to reduce your fine to $100, and I'll tell you why in a second. And I'm going to give you to the end of May. I'll give you till May 31st to get that paid.
Oh, thank you so much, Your Honor.
Okay? But I'm going to tell you why I'm reducing your fines and costs. Because the moment your case was called, you showed the court, even though you're on video, the respect of removing your hat before you began to address the court. That I'll
Thank
sit
you,
here
Your
and
Honor.
I'll hold people accountable for what they do that's wrong. But sometimes we don't tell people when they do the right thing. So I'm acknowledging that you did the right thing in what you did in showing the court respect. And so this is the only way that I can show my appreciation for that. All right, Mr. Jenkins?
I definitely appreciate that, Your Honor. Thank you so much.
The judge notices. In a courtroom full of excuses and arguments, Jenkins' simple respect stands out. The judge lowers his fine to $100, not as a favor, but as a message. Doing the right thing matters. Jenkins is given until May 31st to pay. In that moment, the courtroom shifts. Justice, usually strict and impersonal, shows a brief moment of understanding. This case isn't just about punishment. It's about acknowledging a small act of respect. For a moment, the system feels almost human.